The United States Supreme Court just unleashed a legal earthquake that fundamentally rewrites the gun laws in every single state across the nation. It does not matter if you live in a deep blue liberal stronghold or a bright red conservative state. This changes the rules of the game for absolutely everyone. And the greatest irony of all is that the very people who benefit the most, the citizens whose rights to self-defense just expanded more dramatically than in the last 100 years, are walking around completely oblivious to what just happened. Listen very closely, because what I am about to break down is not some dry academic debate or boring lawyer talk. What you are about to hear is the absolute difference between exercising your rights freely as a citizen and accidentally committing a felony simply because you did not realize which laws were annihilated and which ones are still active in your city. One single mistake born out of misinformation, one wrong step, and you could find yourself standing before a judge facing years in prison. The highest court in the land just pulverized the corrupt, antiquated system that state governments used as a weapon to deny permits to honest, law-abiding citizens. I am talking about that oppressive system where a bureaucrat sitting behind a desk, someone who has never walked through your neighborhood at night, could look at your application and arbitrarily decide your reason was not good enough. They decided your life was not worth protecting. That system is officially dead. It has been declared unconstitutional and burned to the ground, and the new reality that takes its place impacts you directly and personally, whether you reside in New York, California, Texas, Florida, or anywhere in between. In the next few minutes, I am going to reveal exactly what the court destroyed, what this powerful new reality means for your specific state, and the exact steps you need to take right now to protect your family. I guarantee that by the time we finish, your understanding of your own constitutional rights will surpass 99% of the people in this country. But before we dive into the guts of this historic decision, I need to ask you something crucial. Are you subscribed yet? I ask because the legal landscape is shifting in real time right this very second while you are watching this. Hit that subscribe button and turn on all notifications right now. The information I'm about to reveal is extremely time sensitive, and you cannot afford to be trapped in ignorance while the government tries to rewrite the rules. Let us get into it. The case that triggered this massive revolution is called the New York State Rifle and Pistol Association versus Bruen, a landmark decision handed down on June 23, 2022. It was a crushing 6-3 ruling where Justice Clarence Thomas took the pen to write a majority opinion that did not just change the rules for New York. It sent a lethal shockwave through every single state that had ever dared to restrict the right to public self-defense. But to truly understand the sheer magnitude of this victory, you first have to understand the absolute darkness of the pit we just climbed out of. For over 100 years, a massive portion of this country operated under an oppressive regime known as the May issue permitting system. What does that actually mean in the real world? It means the government might issue you a permit, but only if they felt like it. Everything depended on whether a government official sitting behind a counter, someone wielding absolute power over your personal safety, decided your reason was worthy enough. Picture this scenario for a second. You are a model citizen. You pay your taxes on time, your criminal record is spotless, you owe nothing to anyone, and the only thing you want are the tools to protect your family if the worst happens. You jump through all the bureaucratic hoops, pay the extortionate state fees, and sit in front of a licensing board or a police chief. You tell them you want to exercise your constitutional right to self-defense, and that bureaucrat who has never once walked down your street at 2 in the morning looks at you coldly and says that a general desire to protect your own life is not a valid excuse. They demanded that you prove proper cause. They forced you to show a special need for self-defense that was somehow greater than the general public. You had to present documented proof of death threats against you just to convince a subjective evaluator that your blood was valuable enough to not be spilled on the pavement. And the standard, relentless, destructive answer from the state was a simple no. They looked you in the eye and told you that your fear was not real, your life was not in enough danger, and you were simply not important enough to deserve protection. States like California, New York, New Jersey, Maryland, Massachusetts, and Hawaii held their citizens hostage to this desk-bound dictatorship for decades. New York used the infamous Sullivan Law to suffocate its residents for over a century. We are talking about more than 100 million Americans. Nearly one-third of the entire population of the nation lived under the shadow of a government that treated the Second Amendment like a privilege, a little gift the authorities handed out only when they were feeling generous. If you were a Hollywood celebrity, a powerful politician surrounded by tax-funded bodyguards, or someone with high-level connections, the permit was approved like magic. The system was engineered to protect the elite. But if you were a regular person, an honest blue-collar worker, the owner of a small convenience store in a high-crime district, or a single mother forced to cross dark streets after a late shift, the system deliberately disarmed you and left you to the wolves. That was the monstrous May issue system, and that is exactly the corrupt framework the Supreme Court just burned down to the ground. But here is where the story takes a massive 180-degree turn. Two honest citizens, Alejandro Romero and Javier Garcia, got completely fed up with being treated as second-class citizens in New York. Both were good men, hard-working people who paid their taxes and did not have a single blemish on their records. All they wanted was the basic right to protect themselves and their families on the unpredictable streets of their city. The state denied them that right, treating their safety like an afterthought. But Romero and Garcia refused to bow down. They took their fight all the way to the top, straight to the Supreme Court of the United States, and the result was a victory that will echo through every corner of our republic for centuries. The heart of this ruling is absolutely devastating to the bureaucratic tyranny we just talked about. The court established a truth that politicians have tried to hide for decades. The Second Amendment protects an individual's right to carry a firearm outside the home for self-defense. Listen to that carefully, because it is vital outside the home. It is no longer a right trapped inside your four walls. And most importantly, the government can no longer force you to prove a special reason or an extraordinary need to exercise that right. Think about any other fundamental right for a second. Does the government demand that you prove your speech is a matter of life and death before allowing you to speak freely? Do they ask for a special justification before you can practice your religion or before preventing the police from searching your house without a warrant? Of course not, because rights are not privileges handed out by the state. They are not little gifts the government gives you when they feel generous or when they like you. You possess them automatically simply by being a free citizen under the protection of the Constitution. The government can regulate how you exercise them, but it can never, ever demand that you justify why you want them in the first place. With one swing of the gavel, the discretionary may issue system was officially executed. What governs the entire nation right now is the mandatory shall issue system. The difference for you is monumental. Under the old regime, the state could give you a permit if it wanted to. Under the new order established by Bruen, the state shall give you the permit if you meet the objective legal requirements. The subjective judgment of an officer deciding if your fear is real is gone. The ideological filter is gone. If you are a law-abiding adult with no disqualifying criminal record and you complete the required training and paperwork, the state has absolutely no choice but to sign your permit. Period. But here is a massive detail that most people completely miss, and it is even more terrifying for those who want to disarm the public. Before this decision, courts used a legal trap called intermediate scrutiny. The government just had to claim a gun restriction was reasonable for public safety, cite a couple of manipulated statistics from a biased study, and they won almost every time. Justice Clarence Thomas threw that garbage right out the window. There is now a brutal new litmus test the government must pass: the text, history, and tradition test. From this moment forward, when the state wants to defend a law restricting firearms, it can no longer just talk about polls or supposed collective safety. It must prove, with historical documents in hand, that the law is consistent with the American historical tradition of firearm regulation going all the way back to 1791. If a state wants to ban you from carrying your tool of self-defense in a public place, they cannot just invent an excuse. They have to find a real historical analog from the founding era that banned the exact same thing. If they cannot find a solid historical precedent, the law is void. It crumbles. This is the ultimate shield that now protects your rights. Do you think this new historical test will finally stop states from trampling the Constitution? Let me know your thoughts in the comments section below, and smash that like button if you believe freedom must be defended with the truth. All this legal theory, all these scrutiny levels and historical precedents sound incredibly impressive echoing through the halls of Washington or in university classrooms. But the truth is that the law means absolutely nothing until you see how it impacts the blood, sweat, and tears of flesh and blood human beings. Let us bring this decision down from the clouds of the Supreme Court and land it directly on the dark streets where you and I walk every single day. Let me show you how 3 ordinary lives were completely rewritten by this gavel of justice, because these stories could easily be your own. The story of Elena in Los Angeles. Think for a moment about Elena. She is an intensive care nurse working the night shift at an overcrowded hospital in Los Angeles. She finishes her shift physically and mentally exhausted at 2 in the morning and has to walk alone for several blocks in total darkness to reach her car. Over the past year, she has been followed twice by strangers. The sheer terror of hearing fast footsteps behind her became her daily reality. Under the old, cruel system of the state of California, Elena submitted her permit application, paid the exorbitant fees, and poured out her agony. What did the county government tell her? They coldly replied that 2 incidents of being stalked were not sufficient proof of imminent danger. They explained that many women feel unsafe walking alone at night, so her fear, while real, did not make her special compared to the rest of the public. Application denied. Begging for her life and safety was not enough for the bureaucracy. Today, under the unbreakable mandate of the Bruen decision, the scenario is entirely different. Elena applies, completes her mandatory training, passes her background check without an issue, and the county is legally forced to issue her permit. Her reason is basic self-defense, the exact and fundamental reason why the Founding Fathers wrote the Second Amendment in the first place. The ordeal of Carlos in New Jersey. Now let us travel to the East Coast and look at the reality of Carlos. He owns a small grocery store in a rough, high-crime neighborhood in Newark, New Jersey. He built his business through decades of sacrifice, but in the last 3 years, his store has been robbed at gunpoint twice. His employees have felt the cold metal of a barrel pressed against their heads. Carlos went to the state, begging for a permit to carry a weapon and defend the livelihood and lives of his people. Under the old, cynical, justifiable need law, an officer sitting comfortably in an air-conditioned office determined that Carlos did not need a gun. That bureaucrat concluded that the history of violent robberies only meant Carlos should hire extremely expensive private guards or invest in better security cameras. Denied. His life and his family livelihood were left at the mercy of violent criminals. But with the new reality dictated by the Supreme Court, that justifiable need standard simply does not exist anymore. The state cannot tell Carlos how he must value his own blood. He meets the objective legal requirements, and the state has the absolute obligation to hand him the permit. There are no more humiliations and no more begging. The fight of the Mateo family in Hawaii. Finally, look at the family of Mateo. They live in the beautiful paradise of Hawaii, a state that for decades operated as if the United States Constitution did not have the strength to cross the Pacific Ocean. Hawaii was perhaps the most restrictive and suffocating jurisdiction in the entire country. Mateo is simply a father of 3 children. He is not an influential political figure, he is not a retired police officer, and he has not received direct threats from any cartel. He is simply a father who fervently believes in being prepared for any eventuality and who knows his right to protect his family is guaranteed by the founding charter of this nation. Under the old Hawaiian regime, Mateo application would have been shredded and thrown in the trash before he even finished filling out the form. Local courts used to argue that the geographic isolation of the islands justified different, unique, and deeply oppressive rules. Today, justice has completely destroyed that argument. Mateo submits his application, trains with experts, passes all state and federal checks, and the government of Hawaii has to comply. Because the Pacific Ocean does not dilute or weaken the Constitution. Fundamental rights do not magically disappear just because you live on a distant island. These 3 stories are not just theoretical examples. They are the living reality of millions of people who went from being potential, defenseless victims by state decree to fully empowered citizens and absolute masters of their own safety. However, I am begging you to listen to this next part very carefully. Do not celebrate victory just yet, because the bureaucratic beast, seeing itself fatally wounded by the Supreme Court, is fighting back right this very moment in the most vile and deceptive way possible. And if you do not know about their new traps, you could walk straight into a jail cell. I warned you a few minutes ago not to celebrate victory just yet. And this is exactly where the situation becomes extremely dangerous if you stop paying attention, because the politicians in the most restrictive states are not taking this historic defeat lying down. Since the Supreme Court ripped the power to deny you a permit based on subjective whims right out of their hands, they are now attempting a much darker, more cowardly tactic. They are engineering a system so that your permit, even if you finally have it, is practically useless. Immediately after the Bruen ruling came down, lawmakers in jurisdictions like New York and California panicked and convened emergency sessions. How did they strike back? They twisted the law and abused a concept called sensitive places. They are designating almost every imaginable public space as a prohibited zone for carrying a firearm. Parks, town squares, buses, trains, hospitals, stadiums, and even any private business, restaurant, or gas station that does not have a giant physical sign on the front door expressly inviting armed individuals inside. They are weaving a poisonous web, an absolute legal minefield all around you. They want to create a labyrinth where you technically have the official government document in your pocket, backed by the Constitution, but the second you step onto the wrong sidewalk to buy a loaf of bread, you cross an invisible line and automatically become a convicted felon. It is a trap designed to terrify you and force you to leave your tool of self-defense locked in a safe at home. Civil rights organizations are already in federal courts tearing these new traps apart, arguing they are just the old oppressive system wearing a different mask. Some of these laws have already been blocked by federal judges, but the map is shifting every single week. Because of this exact reason, because of this intentional legal chaos, I need to destroy 3 toxic myths that are spreading like wildfire across social media. Listen with extreme focus right now, because believing even one of these lies will cost you your freedom, your life savings, and your future. First deadly myth. The Bruen decision means you can now carry concealed weapons in any state without any kind of license whatsoever. Absolutely false. That is a lie that will lead you straight into a prison cell. The court ruled that systems denying you a permit for lack of a special excuse are illegal, not that requiring a permit is prohibited. If your state requires you to hold a physical license, you still need one. You have to apply. Do not even think about walking out your front door, assuming the mere mention of the Supreme Court will save you from an arrest if you lack the document required by your local jurisdiction. Second dangerous myth. All gun-free zones have been declared unconstitutional and wiped off the map. Completely wrong. The tribunal explicitly recognized that local governments can still designate historically sensitive places where weapons are prohibited, such as schools, courthouses, or government buildings. While it is undeniably true that rebellious states are abusing this exception and expanding it to ridiculous extremes, many of those new territorial bans remain in full effect today as long as a judge has not issued an injunction to freeze them. You have a personal obligation to know the exact list of prohibited zones in your city before taking a single step outside your home. Third deceptive myth. The government can no longer require criminal background checks or mandatory training classes. Totally incorrect. The concurring opinion of the court made it crystal clear that states retain every constitutional right to demand fingerprinting, rigorous criminal history reviews, and live fire safety courses. The court never said the government cannot investigate you or require preparation. What it ruled definitively is that the government cannot arbitrarily deny your right after you have successfully passed all of that vetting. Understanding these traps is the only thing standing between you and becoming just another statistic in the penal system, but we cannot just stay on the defensive. We have to understand where this war is heading next, because the final chapter is only just beginning to be written. Take a step back for a moment and look at the entire battlefield. This legal victory is not an isolated event that happened in a vacuum. It is the third and most devastating strike in a deliberate historical strategy to reclaim your individual sovereignty. Back in 2008, the famous Heller case established for the very first time that the Second Amendment is a fundamental individual right to protect your own home. 2 years later, the McDonald case tied the hands of state and local governments, preventing them from violating that constitutional guarantee. And now, with this revolutionary decision, the Supreme Court has dragged that right out into the daylight, extending it into public spaces and raising the defensive wall against government overreach to levels we have never seen before. The constitutional floor holding up your freedoms is more solid today than at any point in the modern era, and the massive wave of lawsuits currently in the pipeline guarantees this fortress will only grow stronger. But here is the most raw, profound, and real lesson you need to take away today, far beyond any legal technicality. Freedom is not a dusty document you lock in a drawer and forget about. Freedom is a living, breathing muscle that withers and dies if you do not have the courage to exercise it. It means absolutely nothing that the highest court in the land handed you back total control over your own survival if you choose to stay in the shadows out of fear or misinformation. The right to defend the breath of your children, the right to walk through your neighborhood without the paralyzing panic of being easy prey for criminals is the most sacred shield this nation grants you. However, you must burn this into your mind. The law, no matter how majestic and just it is on paper, only serves as armor for those who understand it perfectly and have the courage to claim it. Willful ignorance is the true thief of your rights. Never allow a lack of knowledge to strip you of the privilege and the absolute duty to be the ultimate protector of your family. The map of this country has fractured into 3 distinct zones. You have the freedom states, where this ruling simply bulletproofed the liberties that already existed. You have the compliance states, which were already issuing permits fairly and now can never slide backward into tyranny. And then you have the battleground states, those hostile territories where the laws are being rewritten almost every Friday afternoon just to confuse and disarm you. If you live in one of these legal war zones, your moral duty is to stay on high alert. Get involved locally. Knowledge is the only dividing line separating a citizen who lives trembling in fear of an unjust system from an empowered individual who walks with the absolute certainty of their legal authority. Do your part right now. Share this urgent message with someone you care deeply about. Send it to that person who already carries their tool of self-defense, to that hard-working neighbor who was denied a permit by an arrogant bureaucrat years ago, or to that father who still believes the government will never let him defend his own. Open the eyes of your community, because an informed society is an impossible society to subjugate. Drop a comment down below. Tell me exactly what state you are watching from, and let me know what abuses or changes you have noticed in your local laws. Subscribe to this channel, turn on every single notification bell, and join this resistance built on education, vigilance, and truth. Stay safe, stay strictly within the bounds of the law, and above all else, stay awake and informed. Your freedom belongs to you. Do not let anyone take it away.